Okay, I think we can start now. Thank you everyone for joining us at today's webinar. My name is Samir Amari. I'm the head of business development and marketing at Afridi and Angel. Our speaker today is partner Rahat Dar. Before I hand over to Rahat, I just want to remind you all to submit your questions in the Q&A throughout the webinar. We will go through the slides. Rahat will go through the slides, and then we will do the Q&A and discussion at the end. We'll try to address, and we have had actually a very good experience with the webinars this week. We will address all the questions, hopefully within the 45 minutes allotted for this webinar. The webinar is recorded, and a recording will be posted on our website next week, and it will be shared with all of you. Thank you again for joining, and over to you, Rahat.
Thank you, Samara, and hello everyone, and welcome to this presentation on the UAE Onshore Bankruptcy Law. It's a part of the Legal Updates webinar series, and today we'll be looking at recent developments within the application of the bankruptcy law in the UAE. Now, the bankruptcy law was adopted at the end of 2016. It was largely a reaction following the aftermath of the financial downturn in 2012, where the absence of a reliable and robust bankruptcy regime was pretty much cited as one of the main reasons for the significantly high levels of corporate failures. So in the last few years, we've had a number of cases that have been sort of initiated under the bankruptcy law. And as a result, we now have a better understanding of exactly how the bankruptcy law applies in practice. So during this presentation, we'll look at how this law works in practice. Over the next 30-35 minutes, I'll take you through, firstly, through an overview of the bankruptcy law and the various different procedures that are available under the bankruptcy law. We'll then go and look at some of the trends that have sort of emerged over the last few years as a result of the cases that have gone through the courts. In particular, we're going to look at what are the trends regarding management of cases by the judge and the trustees. We're also going to look at the court's increased interest in transactions that have taken place immediately before the bankruptcy, usually in the 2-year period leading up to the bankruptcy, and the increasing trend of the court to actually challenge those transactions if it thinks those are unfair or fraudulent. In addition, we'll also look at some of the circumstances under which the managers and board members of bankrupt companies can find themselves facing penalties or liability, the extreme case being where they may be held personally liable for all the debts of the company. We'll end off by taking a quick look at sort of do's and don'ts, just general guidance and advice if you're ever involved or part of bankruptcy proceedings, what to do, what things to avoid. Next slide, please. So the bankruptcy law was introduced as Federal Law Number 9 of 2016. It was a very welcome development as it provided support for companies in financial distress in dealing with their creditors, obviously within the supervision and framework of the Dubai courts. The law was very much focused on corporate recovery, and in cases where the business couldn't be rescued, it provided a very valuable framework for having an orderly dissolution of the business, and thus minimizing disruption, not only for the creditors, but also for the general economy as a whole. So the bankruptcy law replaced the previous bankruptcy regime, which was largely covered under Federal Law Number 3 of 1987, and also Federal Law Number 18 of 1993. The bankruptcy law introduced 3 distinct procedures: preventive composition, bankruptcy, and restructuring. We'll take a closer look at these procedures in the following slides. Now, the coverage of the bankruptcy law, it essentially covers all companies and entities that were created or established under the Commercial Companies Law. It includes sole traders and civil license companies such as professional advisors. It also covers free zones, with the exception of the DIFC and the ADGM, both of which have their own individual bankruptcy regimes. Now, the bankruptcy law does not cover government-owned entities or entities that are established under an Amiri decree, unless there is a new law which is issued and making those companies subject to the bankruptcy law. Next slide. Okay, the bankruptcy law has largely been seen as a very debtor-friendly regime. I mean, one example of this is if you compare the debt amount required for a creditor to initiate bankruptcy in the UAE, which is 100,000 dirhams, against other jurisdictions. For example, the UK, where the threshold for initiating action is £750, which is about 3,500 dirhams. And now another example of this so-called debtor-friendly regime was provided in 2020, pretty much during the height of the COVID pandemic, when the bankruptcy law was amended, and in order to introduce the concept of a period of emergency financial crisis. So this emergency financial crisis is broadly defined as a general condition affecting trade or investment in the country, such as an epidemic, natural or environmental crisis, war, etc., determined by the Council of Ministers. So once this period is initiated, there is essentially a suspension of all new bankruptcy applications. Creditors can't file any further applications during this period. Debtors can still file bankruptcy applications, but those procedures can go ahead without the appointment of a trustee or expert, thus making the procedure cheaper and faster. In addition to that, if the debtor can show that its business is affected by the emergency financial crisis, and then it can make an application to the court and ask the court for up to 20 working days within which to reach a settlement with creditors. So that's the settlement agreement, and if it's approved by 2/3 of the creditors, it will pretty much be binding on all the creditors. Cabinet Resolution number 5 of 2021, dated January 31, 2021, basically held that a period between 1 April 2020 until 31 July 2021 was to be considered an emergency financial crisis. This is the only example that we have when this period has been initiated, but certainly there is flexibility to introduce this again in the future as and when necessary. Next slide, please. So the first procedure under the bankruptcy law we're going to look at is preventive composition. This procedure essentially allows debtors to reach a settlement with their creditors for repayment of debts. Usually in practice, this is going to involve a significant write-down of the debt. The application procedure is relatively straightforward. Only the debtor may make an application for preventive composition. They must apply within 30 consecutive business days of payment default. And now it's very unlikely that a company will initiate some sort of bankruptcy proceedings within 30 days of missing a payment deadline. And for that reason, this sort of application is very rare. To date, we're not really aware of any particular instances where this application has been accepted by the courts and gone through the process. The application must show financial hardship, requiring assistance to settle with creditors. This is not an opportunity for you to use the law as a tactic to renegotiate with creditors. Similarly, this option is not available to companies which are essentially insolvent. Again, payment of bank guarantee for scheme implementation expenses is required. This is determined by the court. Court appoints an expert to report on debtors' financial condition. And once that's done, it will go for court approval. If the application is approved, the court will appoint a trustee. Trustee is a very central character in all the bankruptcy procedures. And they hold quite a few responsibilities. For example, collecting and reviewing debt claims, and putting together the procedures and plans, whether for restructuring or bankruptcy, and then implementing those as well. Next slide, please. Now, the procedure for preventive composition, you can generally break down into 4 stages. You get the initial stage, where the debtor submits an application with supporting documents. These will generally include an information memorandum setting out the reasons for the application. You'll also need to provide financials for the company, usually audited. There'll also need to be a report with a 12-month projection. You'll need to provide information of assets and liabilities, a list of creditors and debtors, and also an Etihad Creditor Bureau report for the company as well. These will be initially reviewed internally by the court and then by a court-appointed expert. The court decision will then be accepted usually within 5 days. If the application is accepted, then we move on to the trustee review stage. So here the court will appoint a trustee. The trustee will give notice in 2 local publications, one in English and one in Arabic, about the court's decision to initiate preventive composition. They will also invite creditors to come and submit debt claims within 20 working days. And following that, the trustee will review those claims and will prepare a list of creditors and debtors and for the court to review. Then in the report stage, the trustee will be responsible for preparing a preventive composition plan. This plan will essentially set out the procedure for the proposed settlement and also for the operation of the business during that implementation phase. This will then be reviewed by the court and then by the creditors. You'll get 2/3 of the creditors can approve this. Important to remember, only unsecured creditors can vote on the preventive composition plan. So once it's approved by the creditors, it can then go to the court for final approval, and then we move on to the implementation stage. So once the plan has been approved, it will then be implemented, usually within a period of 3 years, which can be extended up to 5 years if necessary. Once the plan has been fully implemented, and the creditors have been repaid in accordance with the preventive composition plan, technically the business then reverts back to the original owners and managers. Next slide, please. So the next option we're looking at is bankruptcy, very much the nuclear option, in that it results in pretty much the termination of the business and the company, liquidation of its assets to pay off the debtors. This is the most common used procedure under the bankruptcy law that we've seen to date. Now, who can apply for bankruptcy? It's a broad category, unlike preventive composition. The debtors, the creditors, regulatory bodies, and the public prosecutor can also apply to put a company into bankruptcy. The last 2 examples we've not really seen in practice in the courts. It's usually either a debtor or a creditor-led bankruptcy application. So the requirements for a creditor's bankruptcy application are slightly different in that the debt must be outstanding for 30 consecutive business days after the creditor has sent a notice of the overdue debt. The creditor must also show that its debts are 100,000, although creditors can combine to meet this threshold. And there's also a requirement to make a payment of 20,000 dirhams to the court or a bank guarantee. And this is basically to cover the initial debts, the initial costs of the bankruptcy exercise. Next slide, please. So if we look through the bankruptcy procedure, again, it can be simplified by putting it into 4 different stages. You get the initial approval stage. Again, an application is made. You'll submit the documents similar to those of the preventive composition. For example, there'll be an information memorandum. There'll be a credit bureau report. Those are then reviewed by a court-appointed expert. And then the expert prepares a report for the court. If the court accepts the application, it will appoint the trustee. Again, the trustee will make publication in 2 local newspapers, notifying the court's decision, and then basically asking for creditors to come forward with their debt claims. This will then basically culminate in the preparation of, again, a creditors list, which will then be published. And that will then give other creditors an opportunity to either comment on their debt claim amount that's been approved, and also for other creditors to come forward as well. Once the list is prepared, then at the report stage, the trustee is required to prepare a report. Again, this will be setting out how the assets will be sold and how the different creditors will be paid. Again, it will be reviewed by the court, and if it's accepted, it will then be implemented during the implementation stage, which can last for up to 5 years. Now, if you just go back to the report stage, at this stage, the court has the discretion to decide on whether to proceed with the bankruptcy, or alternatively look at doing a restructuring of the business instead, which is what we will look at in the next slide. Next slide, please. So as I mentioned, once you've made a bankruptcy application, at the end, the court has the discretion to approve the bankruptcy, or in the event that the court feels that the bankruptcy exercise is not suitable and that it's possible to restructure the business and basically to have it continue as a going concern, then it can order for restructuring procedure instead. Now, the restructuring procedure will operate in a similar way to preventive composition. So what are the requirements for restructuring procedure? Again, similar to preventive composition, like the preventive composition plan, there'll be a restructuring plan. It will be approved, prepared by the trustee and then approved by the court and the creditors in a similar way. And once it's approved, there'll be a 5-year implementation period, which with a 3-year extension if necessary. Next slide, please. Okay, now we turn to some of the key trends that we've seen as a result of the recent cases that have gone to court. So the first one we're looking at is obviously how the cases are managed in practice. The bankruptcy procedure is essentially managed by the judges with the support of experts and also the trustees as well. Now, the court has taken a learn-on-the-job approach in that these positions, judges, experts, and trustees, are not required to have any specific experience or qualifications. If anything, you'll find a lot of the times the judges and the trustees will be doing the first bankruptcy. So the courts have taken an approach that rather than training them, I suppose the best way to do for them to learn is to actually do bankruptcy procedures. Again, this has been an issue in the past in that various stakeholders in the market have argued that, as with other jurisdictions, trustees, experts should have specific qualifications, chartered accountants, financial background, and so forth. But again, that's not the approach that the courts have taken here. Again, there's no training, formal training or qualifications. Sometimes you'll find judges who aren't familiar with the bankruptcy law. They might be over-reliant on trustees. And again, in that case, you have to hope the trustees experience. Otherwise, it's a very problematic situation. Again, appointment and over-reliance on external experts. This is particularly where the judges and the trustees aren't familiar with a financial analysis. They will generally appoint an external auditor, and then they will not sort of go through the expert's report in detail or scrutinize it in a way that perhaps they should, and will basically give reliance on its accuracy and contents. And again, by appointing external experts, that can be time-consuming and also add to the cost of the exercise as well. Again, given the inexperience, it's not surprising that from time to time we're finding that there are decisions which you could argue are incorrect, or that they have resulted in the law being misapplied or misinterpreted. And again, it's not uncommon for bankruptcy cases to have appeal at one or different stage of the procedure. There are currently very limited number of judges or trustees who will have experience over a number of bankruptcy procedures. So most will not have any bankruptcy experience. and that is obviously a challenge. Again, inconsistent application of the bankruptcy law, mismanagement of cases. As you will have seen from the previous slides, there are timeframes within which various activities have to be completed in practice. Those timeframes are not complied with. Again, the trustees and the courts may introduce experts at unpredictable stages. They may require reports with short notice. So again, it can become a very challenging exercise. Another issue is obviously limitation on fees for experts. As you'll see earlier on, the initial review expert is limited to 20,000 dirhams. And other reports also have a threshold in terms of how much the experts can charge. Again, this has the undesired effect of limiting the pool of professional experts who may otherwise have been involved in the bankruptcy exercise. Next slide. So another trend we've seen is the courts being more and more eager to look through previous transactions that have taken place, mostly in the last 2 years leading up to a bankruptcy application. So again, the courts are really looking at cases where there has been either fraud or some sort of wrongdoing. So you're looking at cases where just before bankruptcy is being filed, we're seeing valuable assets of the companies or subsidiaries are being transferred over to affiliates or related companies. You're suddenly finding assets are being sold at a significant undervalue. You're finding that directors and other managers are suddenly being issued significant bonuses when the company is actually performing very badly. And again, there are other examples that we've seen. And so generally, the courts do have a power to apply a 2-year rule regarding voidable and fraudulent preferences. These are essentially transactions during the 2-year period preceding the initiation of bankruptcy proceedings. And the transactions can be reviewed by the trustee to determine whether they should be set aside as being an unfair preference. So examples that have been given under bankruptcy law include donations or gifts, settlements of debts, otherwise than as agreed. So if you have a list of creditors and one you choose to settle immediately before going into bankruptcy and you leave the others there, payment of debts before they are due, again, accelerating repayment of debt for a preferred creditor, and or the creation of any new security interests of the assets of the company for an existing debt. Now, the courts have the power to terminate transactions that are harmful to creditors. And if the transaction counterparties knew or ought to have known when entering into such transactions that the bankrupt company has ceased payment or to its creditors and was in financial difficulty. So basically, if you know a company is in financial difficulty, then perhaps you should reconsider what sort of transactions you enter into, because if that company then subsequently goes into bankruptcy, you may find the transactions or the settlement or whatever that you've entered into with that company may be either reviewed, and in certain circumstances, those transactions may be reversed. If that happens, then the counterparty is required to return any assets received or pay the value of the disposed asset. Usually this will be the value on which it received the assets in the first place. So if there has been a deterioration in the value, that's going to work against the counterparty. The counterparty is also required to repay any income derived from the bankruptcy company's assets. So if they're income generating assets and they've been used to generate income, that income could also be taken by the court. Court may approve any transactions if they were conducted in good faith for the benefit or continuation of the business. This is obviously the one exception to the termination of transactions if you can show that they were done for a legitimate reason and for the benefit of the company. Next slide. Now, another trend that we've seen, which is obviously very important for managers and directors of companies, is the increased tendency of the courts to look at the conduct of the board and the managers, and to see if there are situations under which they've breached the bankruptcy law and whether they should be subject to any sort of penalties. The extreme example of this is obviously situations where the managers and the directors have been held personally liable for the debts of the company in whole. So focus and risk changes from debtor, company, shareholder to creditors. So essentially, when you're running a company in the normal circumstances, management's focus would be to do things that are in the best interests of the company. However, once a company is in financial difficulty, we would urge managers and directors to also keep in mind whether the actions they are sanctioning and undertaking also have a detrimental effect on the creditors, because this is the prism through which the courts will look at those actions once a bankruptcy application has been made. So once a company is in difficulties, the directors should take certain steps to ensure that all transactions are properly done and ask whether those transactions could be detrimental to creditors. So one example of where the board and managers were held liable was the case bankruptcy for Marker Holding PJSC. This was a major retailer in the UAE. Its assets, when it came to bankruptcy, were found to be worth less than 20% of its debts. The judge also found that there was significant mismanagement of the company, and actions were taken which led to depreciation of its value. And as a consequence, the courts held that the board should be liable to pay the full debts of the company, which came to just over 448 million. Now, the bankruptcy law doesn't just put liability on the board of directors. It applies a more general definition of manager as well. So under the bankruptcy law, there's a very broad definition for manager, which includes any person working at the legal entity subject to the provision of the bankruptcy law and playing an active role in the decision-making process shall be considered as manager. This shall include the person under whose directives and instructions the managers operate. Now, that's very important because it's not just looking at who are the board directors on paper, it's also looking at who is in the habit of instructing them on how they run the company. So you're looking at situations where you may have a family group company where the key person, even though they're not on the board of lower subsidiaries, may still be in the habit of going to those board meetings and directing the board on how to vote on particular issues. Other situations we've seen in the past are where you have operating companies where the managers and directors have left, and as a consequence, the parent company's board managers are making all the decisions. They're coming to the board meetings, and they're essentially acting as de facto managers and board members themselves. So under those sort of situations, they could also be deemed to be managers of the company in bankruptcy. The courts apply a broad understanding of board and management. In our experience, there doesn't seem to be an understanding of the distinction between executive, non-executive, board members who are there mainly to represent shareholders. The courts don't make that differentiation. They apply one rule, and they pretty much says you are board and you are management, and therefore you are liable. Again, collective liability, generally under the law, the courts should identify what liability attaches to each board member and the threshold or the extent to which their liability is. But in practice, the courts usually hold the whole group as liable individually or collectively for any particular debt or any particular liability. They don't go through the detail of identifying what individual acts by individual managers resulted in losses. So that's another thing to remember as well. Cases of misapplication of penalties under the bankruptcy law, as we discussed earlier, sometimes the lack of experience at the court and the trustee level results in misapplication of penalties. So basically, they will reinterpret the law incorrectly and apply it incorrectly, resulting in penalties where they shouldn't have been penalties. Next slide, please. So we're just wanting to put together certain examples of when board and managers have found themselves in difficulty. Again, this is largely based off case law and our own experiences on bankruptcy proceedings as well. So the main one that we gave the example on the marker case was where the board and the managers were held liable for the debts of the company. Now, this is a two-limb test in that, firstly, the assets of the bankrupt company need to meet less than 20% of the debts. And then in addition to that, the courts will look at the conduct of the board and the managers during the 2 years following the opening of procedure. In particular, they'll look at examples of whether they've been selling assets at undervalue, selling assets without consideration, or basically undertaking other settlements of debts with certain creditors and at the detriment of others. Now, in practice, again, the courts will apply a broad blanket liability on the full board and the managers. So again, if you are in a company which is facing financial difficulties, then you should make sure all these decisions that are made with regards to disposing of assets are done and are minuted. And if you don't agree with anything, then your objection is also recorded in the minutes of meetings. That's very important because that could be a potential defense in the event that the liability is found to attach to the board. Again, other examples, you're looking at you're concealing or you're damaging or you're otherwise destroying financial records, the books and of the company, and thereby basically not enabling the court and the trustee to do their job properly. Or the fact that you've just been mismanaging the company, you've not been keeping up-to-date records, and that you've been using fraudulent methods to basically fiddle the figures. Again, the penalty for this is imprisonment of up to 5 years and a fine not exceeding 1 million dirhams. Next slide, please. Yeah, two other examples will relate largely to negligence. Again, disposing of assets and undervalue, paying certain debts at the compromise of others. Again, imprisonment of up to 2 years or a fine not exceeding 60,000 dirhams. Final example, again, another one where we've seen board and managers breaching this and being liable is in relation to failure to maintain company records, financial records, and information which is necessary for the trustee to review the accurate position of the debtor and their expenses and liabilities and so forth. For this, again, you're looking at an imprisonment of up to 1 year or fines not exceeding 30,000 dirhams. Again, this is not a full list of all the potential liabilities under the bankruptcy law. And in addition to that, the liabilities of managers and board are not restricted to the bankruptcy law. There are also liabilities in other legislation as well, including the commercial companies law and the penal code. Next slide. Okay, finally, we're going to move on to do's and don'ts. So these are basically some hopefully helpful tips for you in the event that you find yourselves involved in any of the bankruptcy procedures, whether as a creditor or unfortunately as a debtor company or its managers. So again, plan your strategy prior to application and during proceedings. Bankruptcy case, just like any other, can change throughout its time frame. New arguments could be brought in, etc. So you need to be flexible. You need to appoint a dedicated team of persons to attend to the bankruptcy-related matters. Often the courts can ask you to prepare reports or give information at very short notice. And it's good if you have certain people who are already designated to deal with those issues, rather than basically trying to find new people who are available every time an issue comes up. Also, having a continuity means that these individuals will be familiar with the bankruptcy and able to address issues better than somebody who's picking up the issue new every time. And seek guidance on dealing with potential issues. Again, this is if you have had sales at undervalue, if you had disposed of certain assets to affiliates, if other actions have been taken where you feel there's a potential question mark on the conduct of the board or the managers, then again, that's something you should go and run past legal counsel and find out if there are ways of basically dealing with that issue, or if there are strategies that they can advise you on in terms of how you disclose that to the courts and the trustee. Always be transparent, maintain company books and financial records, ideally audited accounts. If you don't have those, then there's a chance that the courts will appoint auditors, and again, that will increase the cost and the time frame for the whole procedure. Again, keep detailed minutes of meetings, particularly important for directors when they are dealing with companies in financial distress, because if they have any actions that are voted on at minutes and they don't agree with at board meetings, then the minutes are the place where they should have those objections reflected. Do have all the necessary corporate approvals in place for initiating the bankruptcy exercise. Major decisions, past and future, should be documented. Again, board minutes. If the bankruptcy procedure is started, then obviously everything has to be with the approval of the trustee. So make sure you follow those requirements as well, and ensure that you have the capacity and availability of stakeholders. Again, sometimes the trustees can ask for experts' reports to be responded to at short notice. They can ask for new reports at short notice. And if you have multiple stakeholders, it's good to ensure that they have capacity, so that you're not approaching them and trying to get them to give their input on something at short notice. They should be aware that there's a procedure going on, and as with the main company, they should have somebody who's dedicated to dealing with any queries. Decision making within tight timelines for deliverables and responding to reports, as I mentioned earlier. So again, with that, the presentation is concluded. I'm happy to take any questions.
Yes, thank you, Rahat. We've got a few questions, and but not a lot of time. Thank you. That was a very good presentation. We've got like 2-3 minutes. One of the questions that came through is how much control does the original management retain after a company is placed into bankruptcy?
So after it's placed into bankruptcy, if the application is accepted, then they have very little control, because by making the application, they're essentially gone to the court and said, we can't manage this situation. So whilst they may be engaged in day-to-day work of the business, all key decisions like settling with creditors, renewing leases, entering into new transactions, selling assets, all of those need to be taken with the supervision and approval of the trustee. So there is a dramatic reduction in management control.
Okay, all right. And once a company is placed into bankruptcy, what happens to all of its existing commercial agreements?
Well, under the law, all agreements would come to an end once there's a final order of bankruptcy. However, in practice, the trustee may keep certain agreements alive. For example, tenancies, if they need space in order to hold assets which they're going to sell. So the trustee has the discretion to keep certain contracts going, but technically at bankruptcy, all agreements come to an end.
Okay, and I'm just going to ask one last question here because we're running out of time. How do the secured creditors of a bankrupt company get paid?
Well, they will usually have security over specific assets, and the courts will sort of ring fence those assets, sell them. They will deduct the costs of maintaining and selling the asset, and all remaining sale proceeds would be applied towards the secured debtor only, so not the unsecured debtors. In the event that those proceeds are not sufficient to satisfy the debt, then the remaining outstanding debt, there'll be an unsecured creditor for that.
Okay. I think there's one more question. I don't know if we can go through it. And what is the effect to employees when a company declares bankruptcy? Do they get settlement, employees?
Yeah, there are preferential creditors. There's a list of preferential creditors, and one of those is employees and end of service contracts. Again, this is all based on the trustee and what sort of priority he applies. There will be other creditors which are slightly further up the line of preference, but yeah, they will. The aim is to have their payments settled. The aim is to have their end of service gratuity, etc., settled. But again, that's going to be managed by the trustee.
Okay, well, thank you very much. I think we've pretty much on time. And thank you all for joining us today. For those of you who have been joining us, who have joined us in previous webinars, as I mentioned, this session is recorded and it will be shared with all of you. And if you have any questions, please feel free to send them in either to myself or to Rahat directly. You've got both of our email addresses. And we hope to see you again soon in the next over the next couple of days. Thank you. Thank you, Rahat.
Thank you, everyone.